Ms. Clark, in your testimony, you really describe a dazzling array of activities that OSHA was engaged in from the moment that you could first be on the site in terms of the conducting of worker exposure samples and air samples and contaminant samples, and at some point, I think you say it's 24,000 or 30,000 combined samples of the air for all of these various materials that some which we knew would be in the building as a result of the collapse, or what was the contents of the buildings and so forth. What was done with those samples? I mean, those were used how?
The samples were analyzed by our laboratory in Salt Lake City, and as soon as we could, we would provide that information back to all of the safety and health professionals at the site. The contractors, the unions, the other city, state, and federal agencies. We had daily meetings. We met in PS 89, one of the schools that Mr. Cordero mentioned. That was our on-site command post. We would meet there daily in the mornings to discuss the latest issues that were arising, sample results from the various agencies, and
were those samples, I don't know if I'm phrasing this right, excuse the awkward, but were they translated into the on-site experience? I mean, we have, correct me if I'm wrong, and I probably am, but we have standards where this is exposure over 8 hours, this is exposure over periodically during a lifetime. We have different, was there an effort to relate that to what workers were experiencing at the time on the site?
Absolutely. We reported our results the same way we report any other worker safety standard or analysis. What we did is we took personal samples in the breathing zone. That's how we do it in any kind of work site. In the particular situation there, we wanted to err on the side of caution, so we did not use zero exposure for the time frame if the sample was not in 8 hours. So in essence, we reported the highest levels. We reported actual exposure levels. And that was shared with everyone. It was also explained to all of the people there. It was done in separate steward meetings. We actually brought together the stewards on the site for the first time late in September at a meeting, particularly to go over these results.
At no time apparently, and I'm sort of shorthanding this, but at no time apparently was there, well, let me ask you, was there any discussion that these samples and the work site and the exposure ever added up to we should be enforcing adherence to the use of respirators or other safety equipment?
Well, one of the reasons I brought some of these posters that you mentioned before was to show you that...
No, that's advising people to do things.
No, this was a requirement. This was enforced by the site, on the site, by the City of New York, by the contractors. These are orders. You see the middle one is an order from the Department of Health requiring personal protective equipment. These were orders. They were, as you see on the one with the picture,
were they enforced?
They were not allowed to enter into the site areas. They were enforced. I will tell you that in the early days, it was very difficult to enforce because there were a lot of entry points into the site. But there was also a lot of discussion between myself and my staff about what was the appropriate method to take here. We considered the issue of issuing citations, but we decided that that would not work under these circumstances. And this was not a one-time discussion. We referred to this over a period of time.
Ms. Clark, let me just ask you this, because we want to move on here in questions. You know, in the documents that we have received, there is a consistent request from Mr. Kelly McKinney, who I guess was and joining with the union representatives, Liberty Mutual Life Insurance Company, asking OSHA to start taking enforcement actions, and that starts in October. We're talking October, you know, in early October. And so it was obviously September 11th, in early October, and those continue on for a month, constant request proceeding, and no action. So at no time did OSHA invoke its ability to take enforcement action during that time frame?
We did not issue citations. We worked through in
Did you take actions with respect to enforcement?
We considered it appropriate actions under the Act. The Act allows us to, it gives us the discretion to do non-traditional enforcement, which is what we did here. We provided technical assistance. We worked with the other people at the site to establish a safety and health program with mandatory requirements that exceeded our standards. We would not have been able to issue citations except in a very, very few number of instances. We did not have overexposures. If we were to issue any citations, the employer has the right to contest those.
No, I understand that.
During the contest period, they do not.
I'm asking the questions because I'm trying to lay down a baseline,
Okay.
because as I said in my opening statement, the question is why, and we raised the question, are there legal impediments? And when we have what we would consider a non-traditional site and a catastrophic site, as we've had in the two incidents, what that is. So you're saying for the moment here, and I want to go to Mr. McKeon, but for the moment that you did not feel that you could issue, I'm putting words in your mouth, but issue enforceable citations given the law at that moment.
I did not feel that we could issue citations that would provide immediate protection to workers. I could not force immediate protections through citation process, through issuance of penalties. That would not have provided the immediate protection because the law allows employers to contest. Contest periods can take from 2 to 7 years to go through the appeal process. We needed to protect those workers immediately, and that was why we did not choose to issue citations.
We'll come back to that point. Mr. McKeon.